For these videos, I typically answer questions, but in this case, I'm going to ask you a question. Which approach do you think is more fair? So recently, I've got a case where the client, my client, has applied for a US patent and also a patent in Europe, so at the EPO, European Patent Office. Through some confusion, some deadlines were missed. And in the US, what we do is we pay a little bit of money after the fact, and the US Patent and Trademark Office, they're usually willing to revive the patent application. So it was a couple months in this case that we missed the deadline. We came in, we paid the money, and the patent was revived. In Europe, we're having some problems. The EPO is not agreeing to allow us to revive the patent. So I was speaking with a European patent attorney, and I kind of said, well, in the U.S. we just pay this money and we're able to revive. And he gave me the reasoning as to why the European Patent Office does not just automatically grant these revivals. And the reasoning is because companies in Europe, if they see that this patent has lapsed and gone abandoned, then they look at that technology and they are under the impression that they're free to practice this because the patent application has lapsed and it's inactive and it hasn't been revived. So they believe that they're free to practice this technology. And it got me thinking, and I said, I actually see where they're coming from on that. So in the US, you're just able to revive it, and then I guess the duty is on the manufacturer. If they want to practice that technology, then they can do so, but then they kind of have to keep an eye out on whether that patent application has been revived. So it seems like in that case, the duty is a little bit more on the manufacturer in the United States than in Europe. So just sort of a rhetorical question, but I'm kind of wondering what other people think.